Welcome to our podcast. It's brought to you by the Touro Law Review and the Touro College Jacob D. Fuchsberg Law Center. Our topic for today is fair housing on Long Island, with a particular focus on where we are since Newsday's Long Island Divide investigation, and also how attorneys can help combat discrimination. We're fortunate enough to have two very distinguished panelists today, Mr. Patrick Fife, Associate General Counsel of the Long Island Board of Realtors, and Mr. Ian Wilder, Executive Director of Long Island Housing Services. Before we get to the substance of our program, I invite each of our speakers to introduce themselves in a little more detail, and for our law student listeners, perhaps tell them how they came to be at this point in their career and to hold the positions that they hold. So, Mr. Wilder, I'll begin with you. Welcome, and please introduce yourself.
Hi there. My name is Ian Wilder. I am Executive Director of Long Island Housing Services. And I took a very circuitous route to get here. I guess the place to start is law school graduation. I didn't have a position ready at the time. I actually did some temp paralegal work for a while. And I graduated in DC, ended up coming back here to live in my parents' house. Tried practicing on my own. That wasn't going much of anywhere. Ended up doing some side work for some attorneys, including somebody that I'd gone to school with, and ended up working for them for about a dozen years, mostly doing real estate work and some other local legal work. At the same time I was doing legal work, I spent a lot of my time both by myself and then with my wife doing a lot of social justice work after hours. And we would do it on no budget. I'd be doing PR for people and being at protests and events and other things. And it was kind of time for me to combine those things. And I got a job here, but I actually took a job as a housing counselor, not as an attorney. Attorney position opened up soon after. I moved through a number of positions and ended up being executive director here, which is probably the best job I've ever had. I love my job.
Well, I think it's important for our students to hear that. Also important to note that you were doing a related, though non-legal position initially. And, you know, living with your parents, unfortunately, on Long Island, given our topic today, that's you're a bit of a trendsetter when you didn't want to be, but, you know, that actually factors into everything we'll be talking about. So welcome.
Thank you.
Our pleasure to have you. Mr. Fife, the same, please. Let us know a little bit about how you got to where you are.
Okay, great. Thanks, Peter. Thanks for having me. Pleasure to be here with Ian. Yeah, I guess I didn't have the traditional route necessarily either. I'll even go back further. I went to college at Fordham University for my undergraduate. Wanted to be a sports broadcaster. That's what I initially set out to be. Had the privilege of getting tutored a bit by the legendary Hall of Fame broadcaster Marty Glickman, who's was a tremendous individual. I could talk about him for hours, but realized that was not the career for me. Talk about a career that's a very difficult path to or industry to break into. Wound up going into the insurance industry for a couple of years out of undergraduate. During that time, had the opportunity to work with attorneys and said, hey, you know what? I think I could get into that field. That's where I want to go. Had a girlfriend at the time who's now my wife, who was very encouraging and said, hey, go to law school. What do it. So quit a full-time job, lived then with my parents, kind of like Ian said. Went to law school at Hofstra, graduated, and did better than I expected. And I think that's because I had the benefit of working for a few years before going to law school. I literally treated law school like a job. And if I could give one piece of advice to your students out there is to do the same thing. Treat it like a job. And I think you will have more success that way. Wound up then from there, staying on Long Island, working at a law firm, Nixon Peabody, for a couple of years in their Long Island office. Did primarily litigation work, and then decided wanted to move out further to Suffolk County. My wife at that time was going to graduate school, so we kind of supported each other. And wound up at another firm, Toomey Latham. I was there for 12 years or so, and kind of expanded what I did. I liked litigation, but didn't want to be pigeonholed, and got the opportunity to do real estate work, land use, some public interest work, some municipal work, kind of a smattering of things, which was great for me. And then had the opportunity even to work with a lot of small and mid-sized businesses, almost being their kind of day-to-day outside general counsel. And I enjoyed the variety. And then I was fortunate enough, 2020, this opportunity at the Long Island Board of Realtors came up. I decided to go for it, wound up taking a position here. I guess I started 8 days before the COVID pandemic hit. So I was in person in my job for 8 days. And then for the next year and a half or so, kind of interacted with most of my colleagues through this format, Zoom, which was kind of a different experience. But I like Ian, I love what I do now. I'm happy where I am, and I get to do day-to-day legal work, working for a company that has about 70, 80 employees, but we're also a trade association that has about 30,000 members. And so I'm involved not only as a lawyer, helping in kind of the business operations, corporate governance, but also on the education side as well, educating our members about updates to the law, fair housing. So it's a kind of a unique position, but one that I really love at this point.
Good. Well, I am glad you shared that. I think it's important. Again, neither of you had particularly direct routes to where you are. That's okay. And you both love where you've ended up. I'll add that I love my job too. And not many people get to say that. So I think it is important to try to find your way to a place that you feel really, really comfortable. And we'll have you come in for my sports law class. And you can talk about the difficulties of the industry, which is like topic one in that class. But now we turn to really a very significant, serious, important topic. And we'll keep it informal, as our speakers seem to have indicated. So Patrick, let us begin with you. And a vast topic, but maybe you could start by telling us what changes have occurred to real estate laws and practices since the Newsday investigation, and focusing on some New York law, increased broker supervision, training, testing, whatever you think is important. Okay.
All right. Well, yeah, I mean, obviously the Newsday Long Island Divided investigation was groundbreaking. And fortunately, its impact is still with us, and it's created a substantial number of changes at the state level in terms of new laws that have come out, and I think also at the industry level, not necessarily with laws, but in terms of practices and recognition of fair housing. So I'll just talk briefly about it at the state law level. So, immediately following the investigation, the state Senate undertook hearings. I think the first one was in December 2019. They then held a second hearing September 2020 that was delayed because of COVID. And they actually used their subpoena power, which I guess that in and of itself is a pretty rare thing for the Senate to do. Students can check out the hearings. I think they were all recorded. They're available online. The second set of hearings was done over Zoom. So that was kind of an interesting, I guess, thing, because I don't think the Senate had done hearings like that over Zoom before. They ultimately issued almost 100-page, I think it was 97-page investigative report in early 2021. And then late in 2021, the governor signed 9 new laws that related to fair housing and really targeted the real estate industry. And the industry was behind them. The New York State Association of Realtors, which is the trade organization for all realtors in the state, the local association supported these changes. And you mentioned, it really focused on 3 things: real estate broker supervision, increased training for real estate licensees, and also increased funding for testing. Because the Newsday investigation utilized undercover testers, and I think the state Senate felt that's a real great way to kind of see, are these laws being followed? And it's an enforcement way to utilize enforcement mechanisms, but it's expensive. So as far as broker supervision, the state created mandatory standard operating procedures for real estate brokers. Said that all brokers in the state have to have standard operating procedures for prospective home buyers that walk into a real estate office. And the brokers have to make sure everyone in that office is following them, and they have to publicize them. So members of the public know, is this broker treating me the same way it says it's treating everyone else? So there's transparency there. And so does the broker, and it's 3 things: does the broker require identification when people walk in the door? Do they require an exclusive brokerage agreement? And do they require mortgage pre-approval? Because that was one of the things that the Newsday investigation found was, you had people walking into offices being asked for different things, told different things, being treated entirely different just based on, who they were, as opposed to anything else. They also increased or set qualifications for office managers in brokerage offices. A lot of the brokerage offices, I think they found, were large. They had many offices, they had office managers, and oddly enough, the law up until this change didn't define what an office manager had to do. There was no legal duty. So now the law says if you're an office manager, you have the same duty of supervision that the broker has. So you have to be involved in regular personal guidance, instruction, oversight of anybody working in your office. So I think the state helped create an oversight structure and really force communication within the office so that people working for a broker know, hey, this is what the broker requires, and there's that constant communication. State also real estate license training. They've now required implicit bias and cultural competency training for all real estate licensees. That just went into effect this past September. Just like attorneys have continuing legal education requirements, real estate licensees have continuing education requirements. But the state added that as something beyond the fair housing training that licensees already have. And they increased the funding for testing. So those were the 3 things they did. And just at an industry level, I just want to say, again, the industry itself supported these changes. And they've also made a lot of changes internally to increase training, increase the focus on fair housing, the changes to the Realtor Code of Ethics that I could get into if you want, but it's a whole, if you're a realtor, you agree to abide by a code of ethics. It's a little different than just having a real estate license, being a realtor. Little different, than really almost any other trade association. But they made changes to the code of ethics that go towards fair housing and treating, everybody, treating all individuals equally. So, I don't want to. I can talk about that a lot if you want, but I just that's what's happened at the industry side, that the industry's kind of embraced this and agreed that there are things that can be done and more that can be done in the future.
Well, I would like to talk about maybe a little bit about the sort of continuing legal education and its focus on fair housing training, if you were. But you mentioned a number of things. Well, 3 things: supervision, training, and testing. Ian, if I could go to you, I invite you to elaborate on any of those 3. Sure. And I know you do have a specific interest.
Yeah.
in testing. So why don't you go ahead and elaborate as you feel is significant?
Sure. I would say the whole thing coming out of the Long Island Divided would be an interesting study in crisis management, because I will say that the Long Island Board of Realtors chose the path of getting in front of the problem. Whereas, and Patrick does not have to comment on this, some of the individual real estate agents chose a different path than that, and it didn't play very well. So, and how the state reacted was also crisis management, because people looking to the state for how they regulate. As far as I'm concerned, I have a belief that often regulation actually does industry a favor. I think it particularly happens in the real estate industry, because the public is probably generally not aware of this because it's in the weeds, but real estate agents, or as LIBOR prefers to call them, licensees, are 1099 employees. By the state setting out specific things that the brokers have to do, they're protecting that 1099 relationship, because the IRS can't complain that they're overstepping into treating them as employees, because the brokers can turn around and say, we're required by regulation to take these steps. Because normally a lot of the steps that they're now taking in terms of setting policy and everything else step over from what a 1099 employee does to what a W-2 employee is treated. So I think in my world, it did the brokers a favor. It also provides protection. It provides them the ability to collect statistics, so they can make internal analysis if there's a problem. We're collecting those statistics. There might have been challenges about whether it's discriminatory doing it. So I think the states provided the brokers a lot of cover. I hope the brokers are taking advantage of that to do things to tighten up their businesses that in some ways they may not have been able to do to stay within IRS regulations. I also want to point out the problem we have is not a real estate agent problem. It's a systemic racism problem. And we're looking in one industry and seeing how that plays out. But we have this problem in every industry in housing. One of the things that we're starting to push for is we need similar guidelines for housing providers, for people who own apartment dwellings. One of the things I've been suggesting, it's been showing up in Newsday a little bit, is that I think the place for that might be the municipalities provide the rental permits, that they should require the housing providers to also have set policies, that maybe the municipalities, we can work with the municipalities and they could have a form policy. The other thing is they might want to have something where they increase the fees for the rental permits if the providers are seen as violating these laws, because the state really doesn't oversee housing providers. The towns and the villages do. But I think we need similar regulation in other industries, just like we're seeing the Biden administration step forward in terms of appraisers, because there is a national part in terms of appraisals, and we're seeing the discrimination in appraisals. So the problem is in every industry, because it's a problem we've never dealt with in our society properly. So, and I'm glad we're dealing with it in this industry, but we need to deal with it in housing overall. In terms of the testing, yes, I'm glad that we
Excuse
have
me,
some.
Ian,
I'm
before we
sorry.
go to testing, no,
Sure.
no, please don't apologize, because I asked you to comment on it, but you made some important points. So I do want to come back to you to talk about testing really immediately. But you mentioned 1099 W-2. Certainly our law students are studying independent contractor, they're studying employee, the significant differences. Also the trend, especially particularly among the IRS, to try to have everybody be an employee. I think it's harder to have people classified as an independent contractor than it used to be. So
Yes.
I could understand the value of that. Patrick, though, with respect to some of the changes in the code or whatever, the code of ethics, because the lawyer's code is also, model rules at least, are trying to focus more on bias, et cetera. There really isn't much in there rather than general admonition to comply with the law. So is there any particular point with respect to the code of ethics that strikes you as significant?
Well, I mean, the most significant change I would say that to the Realtor Code of Ethics that was made, not directly in response to Newsday, but certainly following it, was that at the National Association of Realtors Code of Ethics, which all realtors have to abide by. And just to make the distinction for your students listening, so all realtors have to be real estate licensees, meaning they have a license to either be a broker or a salesperson, but not all real estate licensees are realtors. It's licensees who choose to become a realtor, and one of the requirements to be a realtor is, hey, I'm going to abide by this code of ethics. And one change that was recently made, and it was really a first of the kind change in I think any industry. It said, and I'm going to look at my screen and sheet and read it word for word. Realtors must not use harassing speech, hate speech, epithets, or slurs based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. And in addition to adding that to the code of ethics, they said it applies in any context. This isn't just in connection with a real estate transaction. This is in anything a realtor does. So, the National Association felt not only is this speech it's abhorrent, but it cuts directly against the mission of realtors, which is to protect and advance the right to real property for all. So if somebody's making these comments, even outside of their real estate practice, that's evidence of one's inability to treat people equally. And so, I haven't seen, other, I'll say, associations kind of go to that effort, but it's something that is now part of the Realtor Code of Ethics, and something, and the Code of Ethics is actually enforced. I mean, that's one of the other things that I'm involved in. We have a whole professional standards department, so a member of the public can make a complaint against a realtor. And there's a whole due process proceeding that then takes place. So it's a kind of an administrative process within our whole industry. There are complaints that are made and they're processed, and there's hearings that are actually held, and discipline can then be imposed.
Well, I'm actually very glad that I asked you this, because as a professional responsibility professor, what the code, by the way, I have my broker's license because lawyers can get them so easily. So I don't know, maybe I'll be hearing from you. But one of the big debates going on with respect to the model rules is whether they should apply to sort of bias, et cetera, outside of the practice of law, which is what you just said the realtors are doing. It's not just within your office, but if you're running around, harassing and discriminating in other aspects of your life, should that be prohibited by the model rules, which every state of California adopts? So that's really a parallel discussion that's happening. Although realtors may be further along with that, that's very interesting. But, we can make all these changes and they're significant, but has to be enforced in some way, which brings us right back to testing. And so, Ian, I invite you to educate us about what testing is in all its detail.
Well, I will give a lot of credit to Newsday. They did a very good job of educating the public about the most common type of testing, which is where you have two testers for comparison. When we talk about testing, it's kind of like what most people would think of as secret shopper, except it's ratcheted up to a level where we have a chain of evidence and everything is carefully constructed, that if it has to end up being used in court, it's of a quality that can be used in court. Thankfully, in New York State, we have a one-party recording law, so we are allowed to make tape recordings. That resolves disagreements very quickly, because when we get to the point where we share recordings with someone we have a testing complaint against, human memory is an imperfect thing, But it's very hard to deny your voice on a tape saying what you said. So the most common scenario, as Newsday describes, is you send out one tester within a protected class. So that could be someone within a certain racial category, someone with a disability, someone with a certain type of source of income, and you send out somebody who's not within that class. And you see if they treated differently or if different things are said to them. Often, as in the Newsday series, discrimination is not explicit. People, except for that one agent who mentioned, "I don't want to steer, but," a phrase that should have blown up in her head the second she said it. But there is, most of the time, it's how the people are treated, what opportunities they're offered, what they're told is available, even if they get callbacks. What if they're given a phone number, what phone number, if they're allowed to see something, if they're given forms to fill out or not, if they're told that they have to have a mortgage commitment before they're taken out. Terms can vary a great deal in what people are offered. Now, I will tell you that we do testing at a level where it's not a mistake. It's not somebody was about to leave for lunch and just treated somebody quickly, or they were hungry and they were just running out the door. Our testing is done in a way, we've been doing this for decades. It's done in a way where it's very clear that there is a pattern here, and we will not bring a complaint unless we believe that it not only meets the standard that the administrative has for probable cause, but that we believe if it had to go to federal court, we would win. Because our reputation is the strongest thing we have. If anybody's been involved with civil rights legislation, you already have strikes against you when you're doing it. So you want to make sure you have an extremely strong case. And on the other hand, we're very happy if we do testing and we find no discrimination. That means people are obeying law. That's a good day for us.
Yeah.
Because ultimately that's what we want. I've said it would be great if we were put out of business, but I don't see it happening anytime soon. So I will tell you, usually when we get an individual complaint from somebody, that complaint ends up being justified. We do have people come in and we assist them. We investigate. We make sure there's something to the complaint. If we carry it forward, usually at the point we're doing testing, there usually is something to it. But we also do testing in the market, because we can't just depend on complaints. We have a huge market here. We have a lot of people involved in the housing industry, and sometimes those come back either insufficient or nothing at all, and that's great. And sometimes they don't. And as I mentioned to somebody recently, sometimes we settle complaints with people and then they supposedly put policies in place and everything should be fine. And then we get more complaints and do more testing and see the same problem again, which makes me very sad.
Yeah. I mean, I can understand. I mean, you'd like, I'm not sure you'd like to be quote unquote out of business, but you sure would like to switch from gathering evidence against to simply monitoring and having good day after good day after good day. But as you say, we're not there. Make a couple of very important points. I mean, this is really, you've got to know the law as you navigate this. And even things like, New York being a one-party permission state, as you said, meaning as long as you're a party to a conversation, you can record it. Other states are two-party permission, so you couldn't do that. So all that's critical. And you certainly mentioned, how important it is to know the law. So maybe, Ian, you could help us understand a couple of things, and then Patrick, of course, would come back to you. But one, what would be sort of the limits on a lawyer participating in testing? And then given those limits, what can lawyers do if they cannot be involved in testing? Okay.
The general interpretation, and you can correct me since it's more your area of expertise than mine, is that there is a limit on lawyers taking part in basically a fiction or an untruth in preparation for litigation. There's been interpretations of that section to say that lawyers could not be testers because they would be presenting themselves as somebody else in a different circumstance for testing that could potentially go into litigation. I have heard some attorneys who disagree with that, but that's generally the interpretation I've seen, that attorneys cannot be testers for that reason. Now, is there anything else testers can do? The lawyers can do. There's a lot of things lawyers can do. In fact, Touro Law Review was just nice enough to print my article titled 20 Things You Can Do to Fight Fair Housing. Now, one of them was become a tester, but there's still 19 more. I mean, in their practice, there's lots of things they can do. Obviously, they can advise their clients. If they're representing sellers, they can advise their clients as sellers, especially if they want to say, oh, I only want to sell to this demographic. They can tell them why that's not allowed. You know, my neighbors wouldn't like X kind of people living here. Or if they, if it's a real estate broker, they can advise them, especially updates on the law and what the existing law is. Same thing with housing providers. We have had source of income laws in our counties for about a decade each. Yet we are still seeing violations of that law. And not only violations that are things like you shouldn't be requiring a rent to income ratio where they want a multiple of the rent as income. And we can get into what that means, but explicit violations like we don't accept vouchers. We don't accept, housing choice vouchers. We don't accept Section 8, which is explicit, direct, clear violations of a law that's been on the books for a long time. So attorneys can do all those things directly. Now, attorneys are citizens. They can do like everybody else. They can advocate for stronger laws, for better funding, for better use of the funds that go through. They can advocate for additional laws, like the things we're talking about with the towns, with the rental permits. There's lots of things that attorneys can do just as citizens who care about justice in our society. And my belief is that the freer society we have, the better it works. Race Racism has done a study and has found that people in communities of color generally would rather live in a diverse neighborhood, not in a neighborhood of one demographic of people, but they are often denied that choice. Urban League, I believe, did a study that showed if people in communities of color were allowed to access all the opportunities available on Long Island, we would have, and I believe it's billions to be more in our economy. So we are cheating ourselves of full potential. And I think the thing Patrick would probably agree to me with is that housing is central to people's lives. It's where you can go to school. It's the quality of food is available in your neighborhood. It's what kind of social connections you can make, which can lead to what kind of jobs, what kind of influences there are on your children. It affects people's lives so much, which is why I understand, real estate agents might say there's a great deal of regulation on them, but the actions they take have such an influential effect on the lives of both adults and children that it's necessary. Because where you live, I mean, the Obama administration said it well. They said a child's zip code should not determine their life. And every child should have the opportunity, and where you live is unfortunately right now a determinant.
All right. Well, I mean that, I respect your passion and also some of the details that you've given us. One point that you made at the beginning about how to interpret the lawyer's code of ethics. There is, in fact, a section that says you can't make deceptive statements to third parties. Of course, it's very general. And then, as you said, it can be interpreted. It's got to be interpreted by bar associations, et cetera, and ultimately by the court. And if they feel that that kind of investigation is causing the lawyer to be making a false statement to a third party, you run afoul of the code. Yes, that's disputed among lawyers. I mean, investigations
Yeah.
are legal as well. I will give you, go ahead. I'll give you a chance to come up, and then I want to go back to Patrick, please.
Sure. I go back to Patrick. I will want to say, I believe there are some places that have carved out an exception for enforcing things like civil rights laws, where it's not meant to take advantage of somebody, but to enforce the law. And I think that is a discussion we have to have within our own bar at some point.
It's like every sentence we utter is like the basis for another, what I would call, vast topic. So right there's a whole couple hours
Yes.
as to,
Yes.
you know, what jurisdictions have and have not done and should or should not do in terms of that point. But Patrick, you know, you have, I know, a perspective as to what lawyers can do and what other improvements may need to be made in the law, or, you know, whatever criticism you may have. So what, if you don't mind, tell us what you think lawyers can do, and then we'll go on to maybe where the law might still need some evolution.
Sure. Well, I agree 100% with Ian. I mean, that education is key, that lawyers should be educating their clients about the fair housing laws, in particular real estate attorneys. I mean, I think it should be part of the discussion. We've encouraged, you know, our audience, meaning LIBOR's audience, is real estate brokers, real estate salespersons. We've encouraged them to, hey, you should have this discussion with your clients, with your customers at the outset. We've actually created just this year some tools for them to say, just like Ian was saying, that housing providers don't necessarily understand their obligations. They can't discriminate either. I mean, I know Newsday's focus was central on the real estate industry, the licensees, but it all comes down also to the sellers, to the landlords. And oftentimes the first point of communication, it is the attorney in some instances. I mean, it is often the real estate agent, but it can be the attorney a lot of times. I know a lot of our members get their, you know, referrals from attorneys. So
That's true.
the attorneys are involved in the beginning. And I think it's really critical for them to have that conversation to say, hey, you can't discriminate. This is what discrimination looks like. I mean, we've created these little simple one-pagers, and we've told our members, you know, really, this is something that you should consider putting in that packet when you go to meet with someone. So it's an entryway for you to have that conversation with somebody that this is something you can't do. And I think a lot of sellers, a lot of landlords don't necessarily understand what discrimination can look like, that it doesn't just take the face of outright, I'm not selling to this person or I'm not renting to this person. There's a lot more things that it can mean. So I definitely think education. And I was going to also add one other area where I think attorneys get involved in is even in the commercial space. We're talking about housing, but it's illegal in New York to discriminate in the commercial space as well. So, and I know a lot of attorneys get involved more on the commercial side, and you can have certainly discrimination in of businesses based on a protected characteristic. So I think it's important for attorneys who are involved in commercial transactions to be educating their clients that discrimination in that arena is just as illegal as it is in the residential context.
What I find interesting about this is, I guess, Patrick, particularly from your position, obviously there's a huge, you have a lot of members with all sorts of political views, but it's almost like you're allowed to approach this from a perspective that is not remotely political. This is the law. I'm not really asking whether you think it's a good idea or a bad idea, my potential seller, my potential landlord. And I'm not trying to come off as, a political advocate, regardless of one's personal feelings. This is the law. So let's just have a business to business discussion as to what you need to do. I mean, that seems to me.
It is. It's the law, but I've heard Ian say this too. The one color that matters here is green. It's good for business not to discriminate. I mean, if you think about it, in the real estate context, if you don't discriminate, that means more buyers, right? And that means more competition, and competition typically yields higher prices. And when it comes to, real estate professionals, higher prices typically means more compensation for that real estate professional. So it's just good business not to discriminate, in addition to being the law. And we've tried to advocate that point as well. So, it's there's dual purposes here. It's not only the law, but you're going to make more money if you follow the law and don't discriminate.
I'm sorry, Ian, I want you to go. Go ahead, please.
Yeah, I even see it as a business opportunity. I'm surprised that I haven't seen a broker jump in the front of this and say, look, we've seen this problem and this is who we are, and we have these things in place. And in order to bring in, especially millennials who are much more interested in non-discrimination, to bring in communities that have felt uncomfortable necessarily dealing with professionals. I think there's what in Harvard they call a blue ocean strategy here, that you could turn this around, and what Patrick's talking about, and use this as a business plan. I think there's even more here than just not discriminating. I think you could put it at the front of your marketing. So besides it being, and I agree 1,000%, there's so many capitalist arguments for obeying what the law already is, in terms of having more people available. And the bigger the market is, the better off everybody is. So I'm sorry, go ahead.
No, that's fine. I mean, when capitalism and social justice merge, does the world blow up like antimatter, or does it become a little closer to paradise? So those are two great, very different perspectives that are bringing us to the same conclusion, the same goal, really.
Well, I would argue that they're not as far apart as you think, because the textbook definition of capitalism is buyers and sellers with equal information and equal power. And when you have discrimination, it's because you have a power imbalance, which to me isn't capitalism. I would say getting rid of discrimination is getting closer to what textbook definition of capitalism actually is.
Okay. Patrick, you can comment. I don't want to end this, so I absolutely will not. That's the one power that I have. I want to keep it going a little longer, and Patrick, maybe you could pick up on that, or you could turn to some of the final topics that we wanted to address, which are areas of law that need more attention, whether it's lawful source income or co-op transparency, or accommodation. I mean, again, three vast topics, but I would like you both to comment on any or all of those. And Patrick, let's turn to you if we may.
I'll start quickly with lawful source of income. I know Ian's touched on it a bit, so I don't want to go too in depth, but I think there needs to be more education on that topic, and we as a real estate association have started to try to do that. Ian mentioned lawful source of income. It became a protected class in 2019 in New York. It just seems like a foreign concept to a lot of people. They hear lawful source of income and they get kind of lost in the words. That's the way I think it is, that it's just something people aren't used to necessarily hearing. And the way I explain it to our members when I teach it is, well, a housing provider can ask you about income. They can say, where do you get your income from? They can ask you for documentation, proof. Where does the income come from? But they have to treat it all the same. They can't say, Ian, he's got a job, and, Peter, he gets his money from Social Security. I like Ian better. You can't do that. You have to treat them all the same. And lawful source of income includes so many different things. We talked a little bit about vouchers in Section 8, but it goes further than that. It's alimony, child support, Social Security. You have to treat them all the same. You can't discriminate, favor one over the other. And another area another nuance within this for real estate licensees that we've tried to educate them on is, there are exceptions to, or protections from not protections, but exceptions to the discrimination laws, saying that lawful source of income doesn't apply to a rental unit in an owner-occupied 1-family, 2-family home. And I think a lot of people hear that and say, okay, great. Even real estate licensees hear that and say, well, I've got, Mr. Jones is renting his legal upstairs apartment. So, the discrimination laws don't apply. So he could say, I don't want Section 8. And no, they do. And that's what we try to get across. Those exemptions don't carry over to the real estate licensee. Once Mr. Jones says, I'm hiring you as my broker, you've got to follow the law. That exemption's gone. There's no carve outs or exemptions for real estate professionals. And we've really tried to make our members and real estate licensees aware that if somebody gives you that instruction, you've got to tell them that's unlawful. I can't do that. And if they refuse, you've got to terminate that relationship, document the termination, end it right there. Possibly consult with an attorney at that point. But we really tried to get the word out to our members and to the public as well. Because again, I think it's not just our members and real estate licensees, but it's the public, the housing providers that need to know. And we created a whole campaign just this summer called Home for All of Us. It's homeforallofus.org. Just to put some information out there to the public, to our members specifically about different housing discrimination issues, and one of them, the first one being lawful source of income. And I know Ian's been on this. I know his organization's brought some lawsuits on this subject. So I'm sure he probably wants to comment on it as well.
I like working with Patrick, and this is one of the few times it's going to sound like I disagree with a couple of things. Source of income discrimination has been illegal in Nassau and Suffolk County for about a decade each. So at this point, by the way, 2019 is now 3 years ago. So there's no excuse. And what I compare it to is that would be like a pizzeria saying, well, the Board of Health changed their rules 10 years ago and I haven't paid attention. Being a housing provider is a job. It's a full-time job. I used to be in private practice. I would tell my clients, if you want to be a landlord, it's another 40-hour-a-week job. If you can't do that, don't do the job. So as far as I'm concerned, I'm not that forgiving. It's been the law for a very long time. Second, the piece of advice I would give everybody is don't look at cutouts in the law, because you will end up getting trouble anyway. Because Patrick mentioned the landlord says, and that's the problem. Once the landlord says, especially if they say, let's say it's a one family with an apartment, but once they say to a potential tenant, I don't, that's a different section of the law, and now it still becomes a fair housing violation. So my general advice to everybody is don't look at the cutouts, just obey the law, because there are exceptions to the exceptions, and it's just easier to just tell everybody than to try and understand the different exceptions and the differences between the laws, and just obey the law. Assume source of income is the law, regardless of whether you have, a 1-bedroom apartment or you have a whole development, and you won't get, you're not going to get in trouble that way. But if you try and depend on exceptions to protect you, you better study the law very carefully, because you may still end up getting in trouble. And yeah, I do find it frustrating that we're still continually finding people disobeying these laws. Now, we bring the cases now based on the New York state law because it's state law, but we have brought the cases based on Suffolk law. We had, as far as we know, the only decision in Suffolk County under the Suffolk law, because when we brought the case was before the state law was passed, against a housing provider on source of income. And it was actually a case that, among other things, they could not do a rent to income ratio, say that their income had to be a multiple of the rent, because when you have a voucher, that money goes directly to rent. So you don't need a lot more money to pay your rent. Besides which, if you have a multiple of the rent amount, you probably, for your income, you probably wouldn't qualify for that voucher anyway. Because if you have that much income, you probably wouldn't qualify for the voucher based on income. So it's a problem in two ways. And we had a decision based in Suffolk on that. It's pretty clear how the state feels on that, but we are still seeing the same things over and over and over again. So I'm glad LIBOR is stepping in to do education, and it's a shame that they're having to do it in a secondary way, and that there's not a direct way, like housing providers or organization that's the equivalent of a LIBOR, that's not educating. And I'm not talking about mom and pop single families. I'm talking about the cases we've had over the last year are all housing developments with multiple units. These are people who, this is their main business, not their side income from an apartment.
Okay.
So they should know better.
Patrick, you could comment on that, or and again, I'm now sorry to sort of say bullet point here, or you could talk a little bit about co-op transparency or accommodation. So I give you your.
No, I mean, again, I agree with everything that Ian just raised in terms of the points about lawful source of income. And we certainly don't teach that there is an exception. It's just what happens is a number of I've heard members go, and I've been at programs where other speakers have said, oh, there's this Mrs. Murphy exemption to the source of it.
Don't.
And then they just hear that and they just tune everything else out. And we're very clear with it. It doesn't apply to you. Don't even think about it. It just block it out of your mind. Like Ian said, the law, as it comes to you, all you need to know is it applies, and you and whoever your customer or client is must follow it under all circumstances. I guess the other issue we should definitely hit on is I think co-op transparency, because I know both of our organizations have been very involved in trying to get statewide co-op transparency. I know that both have been involved at the local level, getting local laws passed for co-op transparency. I know the New York State Association of Realtors has made this one of its legislative priorities year after year, because there is no state law that requires a clear time frame for responses to applicants to co-op boards, or requires that co-op boards provide a reason for denials when someone applies. I mean, fair housing laws certainly apply to cooperatives. There's no question about that. But proving illegal discrimination when it comes to co-ops is difficult, because co-ops, they're not required to disclose their reason for rejecting a prospective applicant, and applicants have to provide a heck of a lot more information to a co-op board than they would ordinarily in a purchase. I mean, they're providing financial information, background information. They're often sitting for interviews, face-to-face interviews, a review process that goes often and then a deliberation that goes on in secret. So it provides a potential vehicle for illegal housing discrimination, because you're getting this board who's learning a lot more about who is purchasing, as opposed to what's, do they have the money? What are the terms? That's, in a sale, that's really all you should be looking at. Whereas these co-ops, because they're looking at so many different things, have the potential to discriminate. So at a local level, there are laws. Suffolk County, I think Ian was at 2009, I think, when their law went into effect. It's been on the books for a while. There is a law that requires certain timeframes be met in terms of acknowledging receipt of an application, time for review, and giving a reason for a rejection if one is given. LIBOR was heavily involved in Nassau County in getting a law passed. Unfortunately, that law doesn't require the disclosure of the reason someone gets rejected. There's only requirements for a co-op board to acknowledge receipt of an application and to respond. But that is certainly an area that both of our organizations feel there needs to be a statewide law that really closes this loophole. And I know I've heard Ian talk about it. I'm sure he can give you more about the benefits of having a statewide co-op transparency bill and why it is so important to Long Island as a community.
Ian, please do comment on that.
Sure. Start with, if anybody from the news, the editorial board is listening, both organizations have a joint op-ed piece that we've been trying to get in about why it's necessary. And Patrick hit on the important thing. And I go back to my argument. If there is, for instance, a management company that covers Nassau and Suffolk, they're dealing with different laws. That doesn't make for easy way to run a business, which is why I like a statewide law. So it's clear, because otherwise you're dealing with different areas that have different rules. It's confusing. What if someone tries to buy a co-op in Nassau or Suffolk and was unable in one and goes to the other, and they have different rights, which also doesn't make sense. It's the time for us to pass a statewide law similar to the one in Suffolk, as Patrick said, well, that has disclosure. And by the way, I'm speaking as a former co-op board member. I sat on my co-op board for 3 years. And I see no reason why you can't give an explanation. I will tell you, the one person I remember us trying to work with and ultimately having to turn down, we gave them a very clear reason about, and it was monetary, why we couldn't approve it. But Patrick is also right. When you buy a house, you don't do a personal face-to-face interview. But when you're joining a co-op, and there are reasons for it, but you're doing a face-to-face interview, which makes the person's demographics and appearance become something that's in the process that you don't even necessarily know on a contract. You know, if the contract says John Smith is buying your house, you have no idea what John Smith looks like or anything else. And you may not, you may not have even seen them when they did the initial walkthrough. The agent may have handled it. The homeowner may not have even been there. The homeowner might not see them till right before closing when they do the last walkthrough. So it's very much needed in the state. And I will say another reason it's needed is because those transactions are so deep in the process, it is very difficult for agencies like ours to do testing. So there's not another way, a good way that we have to enforce the laws, because you might say, well, you guys are out there, you'll take care of it. Well, this is an area where it's very hard for us to take care of it because it's deep, deep in the process. So we do need a law on the books. It's not an unfair law. I'm speaking both in my position as a former co-op board member. It's very reasonable to give somebody a reason why they can't buy. And also that gives them an opportunity to dispute it. Maybe you misunderstood at the meeting. So we're in 100% agreement on this.
Well, that might be a good place then to bring this to a conclusion. So I thank our panelists very, very much for giving us such an informative and really critical discussion. Although I am going to say, let me give each of you, if you want a last word, one thought for us to take from this, I invite you to leave us with that thought. If you want to go first on this, any final parting thought that you'd like to leave our listeners with?
Well, just because attorneys can't be testers, it doesn't mean that our law students who have lots of family members and friends who aren't attorneys can't be testers, because we are always, always looking for more testers. The training's very interesting. The work is very fulfilling. I hear from the testers all the time. So please reach out to us if you're interested in helping enforce civil rights laws.
Thank you. And Patrick, I invite you, if you'd like to leave us with a final thought.
Sure. Well, I guess just this whole podcast is illustrated. There's so many different areas, even within this one specific area, that someone can look into from a lawyer's perspective. So I would just say that encourage your students that just look deeply, because there are a lot of different avenues to get into something. So if you, when you graduate, or if you're in school and you're not particularly happy with where you are or the direction you're going, just explore a little deeper, because there are just so many nuances within each area of the law that there are opportunities to progress to different things. You know, you can find opportunities to ultimately do what you want, even if they're not within your particular job when you graduate or years after you graduate. This industry has a tremendous number of opportunities. So never feel like you're stuck. Keep exploring, and you'll ultimately, hopefully, like Ian and I think, find something you do that you really love and are passionate about.
Well, thank you both very, very much. Our panelists have been Patrick Fife, Ian Wilder, talking about fair housing on Long Island, you know, just a few of the many issues in that regard. But we thank them. I've been your moderator, Professor Peter Zablotsky. It's been a pleasure having you, and thank you very much.